Yes, sir.
What's up, guys?
Yes. This DJ will kick the floor in three, two, 1.
On the troll.
Hello and welcome to Mzansi. We're back again. It's that time of the night. Obviously, if you're sleeping, well and good. You'll find us in the morning.
Yeah.
We do not disappear. We also live the gang, the morning gang. They mark the register. They like the video. I see we have 70 people, 49 likes. Mismatch. We would like to see that competition going on. People who watch us live, matching the numbers as we are going. We would like to see 70 translated to 70 likes, also with subscribers. But that being said, we are back to Discord that has one main character that does almost everything. Almost, not even almost, everything, if you get me. But let Emily unpack that situation as to what is happening, what is situationing there.
Hi guys, welcome back to the Mzansi Reality YouTube channel. Thank you so much for joining us yet again for another deliberation of the Senzo Meyiwa trial. Now let me get into it because a lot happened today. Sergeant Mogane was set to continue under cross-examination by Advocate Mshololo this morning. And Advocate Mshololo started by handing the copy of the SAP 14 to the witness and asking the witness to read paragraphs on procedures of taking a statement. Mshololo said, "You see the document before you," and Mogane said, "Yes, it's a statement regarding the interview with the suspect." Remember yesterday Mshololo said that she was going to make separate copies of different SAP 14 and not use the statement that they had conducted with accused number 2. So Mshololo asked the witness to read part of the document which states police must complete the document in full, whether the person is arrested or not. And the state objected. Baloyi said that the state objects to this line of questioning. We don't see the relevance. The witnesses clarified that the interview on the 17th of June 2020 was not a warning statement. Baloyi said, and what is being read here is in regards to a warning statement. It states that this form is only applicable to the warning statement and whatever follows in this regards to obtaining a warning statement. So the state argued that this is not in relation to an interview. And the judge said, and this precedes the charging of the suspect, as I understand. And Baloyi said, yes, my lord. The judge asked what the law states. Ute, bring me the law, Judge Ratam Khwatling. And the judge asked both legal counsel to get to the law upon which they are basing their arguments. And the court adjourned for 45 minutes. And after they returned, Baloyi said that we are dealing with a mere interview between the police officer and the suspect.
But what does an interview entail in any case? A mere interview, I mean, that is being reduced to just a casual, not even a casual conversation.
Yes.
I mean, that's what was left. But just to look at what that entails. See, with South African law about the interview taken from the suspect, what ought to have happened before that interview? You know, it is important. It's almost the same procedure. I mean, you can play around whether it was what we call it. What do they call it? What were they calling it?
14.
No, warning statements, or
Yes.
it's the same thing, in a sense. In South African law, there are important legal requirements, procedures that should be followed when conducting interview with the suspect. Before interviewing the suspects, the following steps must be in consideration.
Okay.
Or typically be taken into account to ensure a fair legal process. Miranda rights. I mean, we have heard about Miranda rights a lot, right? In fact, it is also there in this, what we call, warning statement. So, for those who do not know what Miranda rights is, just as in many other legal systems, South Africa law requires that suspects be informed of their rights before being interviewed. This includes the right to remain silent, the right to legal representation. Suspects should be informed that anything they say may be used against them in a court. Voluntariness, that is self-explanatory. Legal representation, self-explanatory. Understanding, now this is the leg that later on you'll see Mngomezulu standing on, that there was a lack of understanding on the basis that upon this suspect being taken out of custody for interview, there was that consensus that they are going to deal with the issues of Nongoma case.
Yes.
Which in its merit also, it's a case that is a ghost. I call it a ghost. But then accepting that was the case, there was no understanding, there was no explanation of what happened or what is going to happen, or the interview is going to be about the 636, which is Senzo's case, the demise of Senzo. So in that case, that's what Mngomezulu submitted, that there was lack of understanding, was misleaded. This person was misleaded. That the conversation was only going to be the case of Nongoma.
Yes.
Which he had nothing to do with it in any case. Now, we have seen, I'm concluding that he had nothing to do because they are failing to bring these dockets. Even today,
that stunt that he tried
they
to
keep on
pull.
pulling the stunts. They are failing to bring these dockets. Now, then there's the issue of recording. Here, obviously, if you are going to record the interview with suspects, should be recorded. This recording can serve as an important piece of evidence in future. This can be in the form of writing notes, audio recording, and in this case, I don't know which one they were using,
Neither.
or video.
Is
Neither.
available.
And then time and place of that interview. You know, it's important to extract. So basically, the right to silence in the legal process, all those things. Basically, it does not differ that much. So, in a sense, Baloyi was submitting nothing.
Hey, he kept objecting, Dagabao. He kept getting up. I'm sure today was an exercise of squats. Yeah.
Let us continue, Emil.
Well, Baloyi said we are dealing with a mere interview between the police officer and the suspect. A mere interview. A mere interview.
Of 3 hours. There's no such thing. And considering the fact that this person is not in a tavern where they are discussing that, oh, hey, look, this is what happened and what and what not.
He's in
and
jail.
What. He's in jail. This person is mandated. Some of these things, they come and take you. So you cannot say, no, you cannot take me now. I need to sleep. You know, he's mandated to do that.
Yes. He didn't have much of a choice. Okay, when they said jump, he had to run.
So there is no such thing as small talk of 3 hours, a mere interview of 3 hours. Even the interviews that we go for when we were looking for jobs, they're not 3 hours. It's rare that you find such interviews, seniors and whatnot.
It's for important executive type positions.
So it's not a mere interview. This was a proper interrogation, which includes whatever that we cannot maybe see today that is being argued about today.
So the state said that the interview was informal. Mshololo agrees that we are dealing with an interview between the witness and the suspect, but this ought to have been recorded. The witness said he explained the rights and allegations and to the suspect, and he responded. So it must be recorded. Mshololo read a portion of a previous judgment which states in part, express provision is made in every warning statement in this court's jurisdiction every time a suspect is interviewed. Mshololo read part of that judgment. saying the constitutional protection provided for in terms of Section 35 of the Constitution to arrestees is embodied in the principle. There's no justification for any interview with a suspect arrested or called in for questioning without a warning statement being completed. The very term warning statement indicates the person is a suspect and has been warned of his rights, and in particular his rights to remain silent before such an interview may take place, which is what Mr. Anonymous just deliberated more on. So they were actually supposed to read him his rights before starting that interview. It serves no purpose to attempt to recognize that an arrestee is obliged to say anything, make any admissions, or answer any questions unless he is specifically forewarned of his rights and signs in the warning statement that he has forewarned prior to any such interview or interaction taking place. It was stunning to hear that both the defendants, witnesses who were experienced policemen, believed that they were entitled to question the suspect or arrestee at any time they wished to do so without being compelled to complete a warning statement. Warning statement which is heeded regarding interview with suspect. It is referred to as a SAPS 3M document. So the one SAP 14 is for what? Is for after detainment or after getting arrested, right? So this is a different one that they needed to do for the interrogation process or the interviews. It's a different SAP 3M.
SAP 3M.
In brackets M document, small letter M document, and embodies 12 pages. And on the cover and every first page under the insignia of the South African police statement, the statement regarding interview with the suspects. Now, this form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continues on the portfolio and attach the portfolio to that page. So portfolios must be signed by the suspect, the interpreter, deponents, and commissioner of oaths. So
In that order.
Yeah, the interviewing police officer is required to record that he has informed the suspect of the allegations that is investigating against him or her to ensure that he or she understands the allegations. There's no basis in law or fact to conduct any type of an interview or interrogation without completing such a document. Any attempt to do so will render the arrest and detention of the suspect not only unconstitutional but unlawful.
Yes.
So Mshololo was dealing with the case law on the fact that a statement must be completed and recorded whenever an interview is done,
Yes.
and whether a person is arrested or not. So Mshololo said, my submission is this form does not say it must be completed when a suspect is charged. Right, the one that's completed when a suspect is charged is the SAP 14A, which they have done. But whenever they were taking him for questioning or for interviews or for interrogation, whatever they want to call it, since they are so nice and generous, they didn't complete this other form, which is the SAP 13M.
And it must just be swept under the carpet to say that it was just a mere conversation within two adults that led into an arrest.
So whenever there is an interview by a police officer, it must be completed by the person interviewing the suspect, which is the police officer. It also says that the number of people who were present during the interview also must be recorded. So it must be stated how many people were present during that interview. Because right now, there's a deliberation in court. Mogane is saying it was just him, Mogula, and who else? Mabena. While accused number 2 is saying it was himself, Mogula, Brigadier Kininda, a Bongani, a certain Bongani with braces. So it's not aligning.
The template is like this. There's title, which would say statement or report of an interview with the suspect, case file number, and inserted in a unique case of file number, date and time of an interview, location of an interview, interview officer, interviewing officer, suspect information, and then opening paragraph. That is the beginning, introduction statement, report, providing context of the interview, including the reason for the interview, which would have killed the part of Mngomezulu saying that there was a bit of misleading. Because if they had such title and recorded this and say, this was the case, here is the statement, here is what happened, here is what
this is
the
what
performer.
we asked him. These are the questions we asked, and they would be stated in that form.
And then there will be interview details describing the circumstances under which the interview took place, including the information about who was present during the interview, e.g., it would be officers, legal representatives, etc. And then there's suspects' rights. Now you're mentioning the suspect's rights, mentioning that the suspect was informed of the rights, Miranda rights, before the interview, and whether they waived or invoked those rights. And then interview summary, obviously, that is self-explanatory. And then evidence or exhibits, if there are any. Now, in this case, when they were going to wherever they were going to verify and got that exhibit of some sort of that says that Danz was not there at work, they would have embedded that in the very same whatever the document that they were dealing with on that interview. And then the legal procedure, mentioning any legal procedure and protocols followed during the interview, such as the recording of an interview, the presence of the legal representatives, the administration of the cautionary statements, and then suspect's demeanor that they've been talking about. Note the suspect demeanor during the interview includes the emotional state. In this case, that Mshololo is dealing with by saying that there was no time for this person to rest, that now must be swept under the carpet. Any signs of distress which could be caused by you not sleeping in any case, or anything, or being tortured, must be written there. And then conclusion statement report by summarizing the key points discussed during the interview, any action taken afterwards. Now, in this case, you'll be saying we went to investigate to Rustenburg or wherever we went to check if indeed this person was there, and there must be signature. The statement report should be signed by the interviewing officer and, if applicable, the suspect. There may also be space for suspect legal representatives to sign, and then attachments, and obviously that's how this thing was supposed to go. We wouldn't be here if they followed this template.
No, and there would not be any confusion as to whether he was interviewed regarding the 636 case of Foslerus or all the 3 cases, including Nongoma case as well as the other Foslerus case.
Yes.
Right now, accused number 2 has just testified or gave their version through Mngomezulu that, you know what, I was only questioned with regards to the Senzo Meyiwa case. And Mogane is saying otherwise. He said he had a lot of cases.
Which are not mentioned.
No.
But 2 is a lot. Let us accept that.
So the judge said, have you read Krela's remarks? It was a 3-bench judgment. So the judge here was trying to counteract what Mshololo had been using to make her argument with regards to this form or this SAP 13 that Mogane needed to be questioned on, honestly speaking. Okay, this incompetence coming from these police officers is worrying. And the judge used their own argument to try and debunk that. So the judge said that it was a 3-bench judgment, this Krela's case. There were 3 judges in it, and Krela was the main judge. So the judge is implying that if the accused are saying that they are assaulted, then it's on them to prove that they were beaten or tortured. So he's putting the entire onus upon the accused and not for the state to prove its case against the accused. I thought this is what was happening, but in this court, it seems like our beloved judge wants it to be the other way around.
Indeed, in a trial within trial, it is expected of the defense to prove, obviously, with any evidence that they have that there was, in this case, an assault or whatsoever, and they were under duress or what. But what they have given them for free is such time that has irregularities, where someone didn't sleep. That is a free information. So based on that, they can lean on that, and they are leaning on that.
Yes.
To say that other than what we could not see, the time these people got to rest, the irregularities that happened, the time that is not accounted for, when they were not brought back, that time could have been the issue. There could have been things that were happening there, which the judge now is looking at it in this manner to say that they never even went there. I was even surprised later on. This is later on when he's dealing with Mshololo, in trying to threaten Mshololo in a sense, allegedly, because Mshololo was asking certain questions to say, now you are contradicting the version that Mngomezulu puts. And on purpose, again, in a wrong way, the judge goes north. It's not a mistake.
Well, the judge read these judgments, which among others stated that a criminal trial is not a game where one side is entitled to claim the benefit of any omission or mistake by the other side. And the judge's position is not just an empire to ensure the rules of the game are observed by both sides. A judge is an administrator of justice. Now, doesn't this sound familiar from the R versus Hepworth?
We've been treated with such. We clearly now
but
can even.
But it still doesn't follow it. It's like, why are you reading it to us? It's almost like he's trying to
What he's using it
us.
for is to justify his intervention that he keeps.
Like, I don't get it, because you don't do this, you don't do that. You already picked a side. You're a prosecutor. Today he was a prosecutor, guys.
Yeah, the judge must not become a center stage of the case.
He had taken over Baloyi's job today. He was the prosecutor for the day. And the judge said he's not merely a figurehead. He has not only to direct and control proceedings, but to see that justice is done. The judge read where it is stated that Section 35 provided that even though it might have been obtained in a manner that violates the Bill of Rights, it will not necessarily be excluded, and not every violation of a Bill of Rights leads to exclusion. The judge said that the holder's judgment, which is the one Advocate Mshololo used to argue, is not the be-all and end-all. He says that he has quoted 2 constitutional cases where they even unconstitutionally obtained evidence. Then he started snapping his fingers to Advocate Baloyi there and said, hello, insisting that everyone in the court must read it. He said that he doesn't want people to say, umkhwatleng ukhota umthetho ongekho. So Baloyi was looking for it. So for our non-English speakers to say that Mokwatleng is quoting laws that are not there or that don't exist. So Baloyi was looking for it. So basically what he is saying that is in his court, it does not matter whether the evidence was obtained unconstitutionally or not. Okay. The judge said that this form, according to him, has got no force of law. So he was literally trying to debunk this SAP 13A to say that it's not a must, it's not a force of law. And he asked Mshololo, do you agree with me? And Mshololo said, as the court pleases. I love Mshololo today. He's like, you know what, I'm not going to agree with the stuff and I don't understand. Forcing Mshololo to agree with him. And she's like, as the court pleases.
You see, there is a... Let us just put it in a simple way. Do you remember when we talked about when the search warrant can be forgiven if it's not there. Under circumstances which require you to act swiftly, and where you feel that by intervening you can actually even avoid a bigger damage, in a sense. This is in a broader sense of how these laws are looked at. So, in that manner, it follows that you can actually now look at fairness and unfairness on those bases alone. You cannot unmarry the situation of that with the judgment. So in this case, where you have the side of the police and the side of the accused, if you are objective, you are not biased, if you are not already buying on what is submitted by the police, if you are not affiliated with the police themselves, then you should weigh the situation and look at the circumstances that transpired without, obviously, the medical side of things that could have been suppressed for some weird reason.
Yes.
Look at the irregularities of time that these people were taken out, where the police are claiming that for friendly reason they were just moving around with the detained person or the arrested person, which you have never heard of. You instead look for those cases that are not explaining anything. We have since seen that today. So in that case, you should look at the competence of the police and also look at how much you can trust this police, engage and say, on this basis, then I rule in favor of the defense, because those are the people who did not have control what could have happened. Even though you are saying, based on what you are giving us, that, okay, they agreed. It's your word against their word. They are disputing it here now in court. So there is no consensus. So on those bases, then we can assume that they were threatened. In this case, this whole case, honestly, there is nothing to it. And now you go as further as to submit the wrong arguments just because you wanted to argue. You are arguing on an admissibility of the evidence on the basis that it was obtained illegally.
Yes. So
but Mshololo is looking at the case where the interview was done and it was done in that manner, and the ruling was such that there was irregularities. It is not on the basis of admissibility or what, no. It can lead to that. But as you always like to quote these cases, they are bringing you these judgments. They are bringing you judgment. Then you are debunking it now on the basis of admissibility.
Basically, guys, it was rough. So the judge said, it has no force of law. It's a guideline, but I'm not stopping you from arguing. You can argue. I'm just saying, where is that case? And Baloy said, my learned friend is finding it. No, man, just find it, said the judge. This is where I felt like this is actually not your job, judge.
Yes.
This is the state's job, and you're doing it for them, and you're directing them, and we're supposed to ignore it. We're supposed to.
And when they put that to you, you get agitated and angry.
Like, we're supposed to act like, okay, this is normal, a normal court. No, a normal court of law, a judge does not help the state prove their case or make arguments. It's not normal. And it can never be normal.
When he feels that he's failing, look at his point of departure. He then attacks the form itself, that it was not enforceable by law, but it is a guideline of law. All that we are saying is that you could have actually taken a paper and written all these steps, step by step, You don't need to have SAPS. But if you followed and your steps are such that they are clear and defining the Miranda's rights and all those things, then there is no problem.
Hi, urata uyang stressa nje, because he just keeps getting worse. I think we owe Maumela an apology. No. This is really bad. So the judge said just because evidence is not constitutionally acquired, therefore it is not admissible. He says you need further examine how that evidence was acquired, the demands of public policy, the demands of fairness, the tension between the demands of the police to maintain law and order, and the perceptions of the public regarding the application of fairness. Singena why is
such as
why
I will deal with the demand of public police, but such that the judge eventually went on to complain about democracy. This is someone who is literally saying that democracy is cack.
What did we do to deserve this? A black judge, a black judge praising the system of pre-1994, where people like us were thrown into the jails. Okay.
For fun.
For sitting in the wrong bench, for riding the wrong bus, for sitting or entering the toilets that were not assigned to your skin color in a public place. You would be thrown. Like, so many things were wrong with that system. But here you find a black judge in 2023 saying that actually the judges back then, they wouldn't have done this.
So see, I told you about these laws, but beside that, this is beside the point. The question is, what has he done? I mean, I see he's got white hair now. What has he done himself that left the footprint of what ought to happen about these laws to accommodate even that so-called system?
It seems to me that's not his concern. It seems to me even during that time, he was always with the other team.
He definitely.
With the
it
opposite.
looks like
he
that.
was always against people like himself.
It looks like that.
Very much that, and he has continued to carry on this struggle that he has within himself to please. I mean, we've seen how he behaves with witnesses of the other color.
He's excited to see them. It's like he's seeing.
It's giving.
He's seeing his siblings.
He hasn't transformed. It's giving. He's still stuck in his ways, and he will always be stuck in that time. He's not gonna change. If he preferred it, then
anyone who pride themselves of being well conversant on someone's language, not a good sign.
So I'm like, Singenapi with regards to public perception, because so far he takes offense to what the public has to say. He really gets offended with what the public opinion is saying over all forms of social media.
He said the court is not the YouTube. We are on YouTube.
Yes, and there's also Facebook. Discussions are happening everywhere on every social media platform.
TikTok.
Twitter, now called X. It's happening. The conversations are happening on TikTok. They are happening on Facebook.
Where people such as lawyers that are not allowed to speak in public platforms are speaking anonymously.
So the judge said after that, we can conclude whatever cross-examination you want. And Mshololo say, may other counsels be given the opportunity to make submissions. And the judge said, no, everybody. It seems as though he already had made his ruling then, but Mshololo had to remind him again that
should have let him. You should have let him like the other time. You should have let him like the other time. And indeed, it gave Mshorolo the momentum that he needed. the support of these learned friends who really did. I think they outdone themselves. I was even more impressed by Mnisi's submissions, who was dealing with the issues that there seems to be a position that, without saying it in many words, that the court has taken, even quoting certain...
it has happened before.
Yes.
This movie has happened
He was
before.
just reprimanding and hammering on that. And I was happy. That's why I'm saying it's always good to rest your team when it's unnecessary. In this case, let Mshololo and Mngomezulu, they're fine. They're complementing themselves very well because they are able to talk to each other, and Mshololo consult with Mngomezulu before to avoid the situation where not even that, the court where it uses what it had to say that there might be a contradiction of what this one submitted. They are dealing with the issues properly, and in that manner, without saying a lot of things. I feel like in this case, when they were saying that one person cannot, representative of one client cannot cross-examine a witness twice. It is happening indirectly. So I don't know if you have noticed that Mshololo and Mngomezulu are more like representing one person in this case. Have you noticed? It's all about accused number 2.
Yes.
Mshololo is deep in accused number 2, accused number 1.
But they are intertwined. I mean, I don't see a problem.
Yes, all I'm saying is that that's a flaw of this law. Because it says, it does not say you must not be cross-examined in one evidence that you have given twice. It literally says it shouldn't be that those people are representing one person. But since now we have four counsels, it does not exclude you being moored by 4 counsel.
Yes,
for one person.
Each are representing their clients, so
they are mitigating the problem before it even comes to them, dealing with it before, dealing with the head before it even leaves to see the next day and start biting them. But continue, I mean.
The judge told Baloyi that his register, the lady who helps the judge there, found that law first, or that judgment rather. Baloyi read the judgment into the record because he quickly found it. In fact, he was using his phone. That's how much he was looking for the... So, at the time, fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence albeit obtained unconstitutionally nevertheless be admitted. And the judge said, go on. And Baloyi said to continue to read from that judgment. If the evidence to which the applicant objects is tendered in criminal proceedings against him, he will be entitled at that stage to raise objections to its admissibility. And it will then be for the trial judge to decide whether the circumstances are such that fairness requires the evidence to be excluded. It follows that the applicant is not entitled to an order from this court, and these proceedings that the evidence secured as a result of the search and seizures will be admissible in criminal proceedings against him. So I'm like, at this moment, isn't the judge like trying to stop this from happening, in my opinion, or in my question in my head? I'm like, this law is not really working in the favor of the judge and the state, or I don't know what they're trying to do, but let's listen. Go on. And so the judge said he must read the tension, okay? Why there are reasons like that, because some of us may not know it. Okay, throwing a little shade there that some of us may not know it, okay? And Baloyi went exactly to where he was directed by the judge to go and read. And it seemed like the judge had memorized this passage in his head. I mean, he knows it. He knows it off by heart. And as soon as he found it, Baloyi, he started reading from that part, and it said, in any democratic criminal justice system, there's a tension in between, on the one hand, the public interest in bringing criminals to book, and on the other hand, equally, the great public interest in ensuring that justice is manifestly done to all, even those suspected of conduct, which would put them beyond the pale. To be sure, a permanent feature of that tension is the universal and unceasing endeavor by international human rights bodies, enlightened legislatures and courts to prevent or curtail excessive zeal by the state agencies in the prevention, investigation of prosecution of crime. But none of that means sympathy for crime and its perpetrators, nor does it mean a predilection for technical necessities and endogenous legal stretchments. That what the Constitution demands is that the accused be given a fair trial. Ultimately, as it was held in Ferreira versus Levi, fairness is an issue which has to be decided upon the facts of each case, and the trial judge is the person best placed to take the decision. At times, fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times that fairness requires that evidence albeit obtained unconstitutionally nevertheless be admitted. So in the background, you could hear the judge saying, yes, that's it. Cheering his student on. He could even quote some of the words, like you could tell that he knows this off by heart. So Mngomezulu then, they were given an opportunity to present their submissions. It was Mngomezulu's turn now. And he said, my submission is each case is decided on its own merits. When we look at the interview that was conducted, it was held in the boardroom. It was held under a different pretext. He was booked out of the cells and taken to the boardroom under a wrong case, which is case 163 of Nongoma 10/2018. When an interview is carried, it's carried in terms of a docket that the accused is now facing on the charges of case 636. My lord, the unfair part of the principle in the doctrine of fairness lies on the aspect that if a right was explained to the accused, it was in respect of case 163 and changing tune when they are in the boardroom. So the accused is no longer, as per evidence, there is no evidence that the interview was conducted as per Nongoma case. But all that we know is that an interview was conducted relating to the whereabouts of accused number 2 on the date of the 26th of October 2014. Is it fair for the accused in the course of administering justice to be taken by surprise? To say this is what we arrested you for, but now we are subjected to this particular allegations. Please provide us. To what extent were the rights explained, especially under case 636? Second fold of his submission is that it's based on the evidence that it is before the Honorable Court that in all times that accused number 2 is booked in and out, there is no indication, there is no entry that he was subjected to an investigation under case 636, so that would tantamount to unfairness and that will jeopardize proper functioning of the justice system. In this regard, as matters are decided on their own merits, it is my humble submission that accused number 2 should have been given an information he is on, that he is the one that received information earlier that he is involved in the murder case of Senzo Meyiwa, but when he is booked out and the rights are read in Exhibit LL, the rights are read under a very wrong case number. And the judge said, okay, thanks. Then it was Advocate Mnisi's turn. And Advocate Mnisi says that there is a conflation of issues, saying it was raised by Advocate Mshololo that each time a person is interviewed, it must be recorded. And the state stood up and said that it is not always the case. Mnisi said the court then came in and said the warning statement must precede the charging of a suspect before the legal teams were then invited to bring authority.
3 submissions.
Mnisi said Mshololo has now brought to court the authority the court asked for in the form of a judgment. And Nisi said, we were expecting the state to also bring such a judgment against what the defense has brought forth. Each time there's an interview with a suspect, this form must be filled without exception. That's like, you felt goosebumps as he said that. It's like, it's been a while since we saw Advocate Nisi standing up and speaking.
Always good to rest. Always good to rest.
I felt goosebumps. I was like, what is it? This form must be filled without exception. And Mnisi said, the case of Krela, these two cases are totally distinguishable because in the Krela case, it was not about whether or not each time that a suspect is being interviewed, this document 3mm must be filled in. It was only a determination on whether or not the statements that were used in the decision of this case should be used against the accused person or what. So these two cases are totally different. As I'm standing here, I'm still expecting the state to present the court an authority that says no. It is still fine for a suspect to be interviewed without having to fill in that SAP 3mm.
There's no such.
So
they were trying to canvass that by now they want to create such precedent. Rata wants to leave such precedent where we are going to now be dealt with like that. He wants to create his own.
So the state is not forwarding such information, my lord. We are not saying the court should make a decision here and now, and the judge got hyper. He started saying, no, hey, me, I'm not going to make, I'm not confused. And the people in the court laughed as he said that. And he said, I'm going to make the decision now. You are arguing the law. I'm going to make the decision at the end of the case. Don't go about saying, lily judge. No, I'm listening to the principle of the law, and the decision I make will be predicated in the sense that I gave you all a chance for the input of the very issue which is being debated. But I'm not making a finding. I'm not making a ruling. Never.
But you sounded like you were. In fact, he even further submitted that what he's hearing is a reference now already. Is hearing a reference of to authorities that are seemingly saying that should happen. It is okay for such things to happen.
Well, Nisi said that is basically what would have been my next point. And the judge said that I'll make a ruling. Nisi had him by the choco.
Right.
Well, Nisi said, no, I intend to say that when Mshololo raised the issue of the suspect in the boardroom and whether or not this form was filled, it should be something that my colleague should be allowed to proceed with that form of cross-examination. It will then, only after all the evidence at the end of it has been heard, okay? So the judge said, I said that to her, asking Advocate Mshololo that he is not stopping her from cross-examining, that she should continue. So the state disagreed that the interview required that formal process to be followed, stating that the interview was just preliminary processes that did not require the pro forma form to be filled and should be seen as a statement by the accused. Then Advocate Zutulele Ngumalo said it is not enough for police to use the SAP-14. And Baloi said that the suspect was merely told that there was an investigation into the Senzo Meyiwa murder, and the suspect of his own volition responded that he had read about it in the media and that he didn't make a statement when he said he was at work on that day. It's not a statement but an alibi. This form is irrelevant on the basis of evidence. So Baloi went on and on arguing why that form should not be considered, saying that Mshololo was asking about the statement. So it had nothing, basically. That's what I'm trying to say, but it didn't have much weight. Okay, he didn't have something that.
No, he was saying nothing, basically.
He was just talking because he speaks
The mouth
good
was
English.
moving, yes, indeed it was, my lord.
Yeah, he speaks good English.
Indeed, my lord.
Sometimes you get lost and you're thinking he's saying something. He's saying something.
Indeed, my lord. We submit that.
And then you're like,
on the basis of relevance.
What have I just been typing? It's a bunch of nothing. And then you decide, let me stop. Let me just summarize.
On the basis of relevance, my lord, we submit that just a simple moving a mere conversation between two adults and now saying that it was an interview, my lord, we submit that on those bases, my lord,
nice
the relevance
that sounds so nice. It sounds
rather
like Mr. Anonymous is saying proper stuff, eh? But
I'm saying nothing.
Exactly. So that's what happened.
So what
With his arguments, I even saw that the judge was kind of pissed off.
It was okay. He was shaking his head. So what constitutes a formal statement?
What constitutes
An informal statement? That is what I wanted to know. Because under the circumstances, the accused was at or is still at being detained. There is no such thing as informal conversation there.
No.
Unless you are speaking with your inmates.
No, there's no such.
If you have inmates. There is no such thing as so anything that you are taken out of to come and even if it's to just look at a certain car and see if it's yellow or blue, you must know that they are dealing with you.
Yeah, so just before Mshololo was set to continue with cross-examining Mogane, the drama began. Ging. Waqala uMgani, waqala wasibhayizisa, wathi uyasibhayizisa uMgani. This is how it went down. So Mogane asked to address the court. Mogane said, yesterday I was asked to bring documents of cases. I have brought those cases and I have written everything as well as the names of people. Mogane said, I gave that to Advocate Baloyi in an envelope during the break. The document was written confidential. I saw it running around amongst the accused.
Yeah.
And the judge said, who had it? Mogane was like, I saw Muzi having it and the other suspects were reading it.
Yeah.
The judge said, who gave it to them? Mogane said, I don't know. Mogane said, I'm worried for our witnesses in those cases. And some of those cases also affect some of the accused. In all these cases, there are firearms that are involved. People have been shot. People have been kidnapped. People have been kidnapped and others have been threatened. Now I'm worried for my witnesses. And Mogane said there are a couple of case numbers in there. And it is possible that they then get into our systems to get the names and addresses of people and insinuating that they will pow them. Okay? Mogane said Advocate Mngomezulu brought a document that shows information on the Kwanongoma case from their system.
The one they are denouncing.
Of the SAPS. The one that he's denying, by the way. Yes, Mr. Anonymous. The one that he said...
now he's accepting as a verified document?
It's just an extract. It's like a paragraph that summarized the case. It's not an entire docket. Mogane.
Okay, so let us think. Let's look at this. First of all, I don't believe that any of the defense put that thing there. They have never done it before. On those bases, I would submit that they didn't do it. Even though the judge has taken a position as to insulting them, even insinuating that they did it. He knows it's them. You know? Mm-hmm. Yet, on his submission, this Mogane guy, he said he gave this document to Baloyi.
Advocate Baloyi.
Baloyi reproduced it.
Yes, made copies.
In a manner in which this judge is favoring Baloyi, he jumps that whole process of investigation. He goes and points at the defense. Later on...
No. He did not ask to see what the document was that they were looking at.
And he also did not question the issue that, Baloyi, you are given this original document, you reproduced it. How did it come to sit in these people's desks?
Persons.
If that happened, I will tell you, if that happened, it was on purpose, according to me. If that happened, it was on purpose. It was done by someone who wanted that to happen. Why would I say that?
Why?
Because the cases that are there, they might be cooked, allegedly. They might need to follow up on them and then find that these cases are cooked. But look at it this way. Maybe they are cooked. So one way of giving and removing that information before someone gets to look at it thoroughly is by claiming that this is some documents from high intelligence of, I don't know, first class, if there's something like that of intelligence. And then say, okay, because you have broken that rule, I'm taking it. I'm not going to finish it anymore. No one has...
It felt like that was going to happen. Hey?
So he wanted to rule in a manner of apartheid, as he was even quoting the apartheid laws and what happened when the judges were during those times. He likes them. I think he had all the time to learn about them. He was in Athens around that time. He was learning. I'm sure everyone that was represented by him probably was going to jail if the system felt so. As obvious as alleged.
I wouldn't want him representing me though.
Well, in the process of that break, something happens.
Yeah.
And they realize, they say, no, look, we need this evidence for these lawyers to actually approve that, in fact, these cases were resurrected, as he put it like that. So therefore, there was that business. They need this evidence to justify this irregular hours. Then he comes back after consulting something that I don't even know. Did you hear what he was reading there?
I did a glimpse.
It didn't make sense.
It didn't.
But he was reading something as if he's giving a judgment and order, something. And he comes back, he gives it back. So the plan
perhaps
did not work. Or the plan was to make these people not to look at these documents properly and vent them to see if there's originality. When were these cases, for example, resurrected? Was it 23 October? Was it today? When? You know, and what was the process after that investigation? Has there been any investigation since the resurrection of these cases? And does it justify or does it align with the hours that they were saying these people, they were going and investigating and whatnot? What was the investigation, therefore? What ended up being an investigation? So such things, now they're going to have to be looked at. So they realize in that break, this is for me, this is my own theory, that if we take this thing away, these people are going to claim that they were not privy to certain information. The judge revoked and took that information away from them. So we need these people to accept the theory that actually there was an investigation that was done, because that is the purpose of those cases actually.
Yes.
And they might also get to see even more, because some of these cases they will need to come with dockets.
Yes.
Now that is the problem. So the initial plan is to take it away. Oh no, we need it.
And I'll expunge it. Okay,
We need
let me
it.
get into it.
This court does not.
expunging
Do you
it.
remember this court does not expunge things?
Well, he was expunging today.
This was during Nisi's request.
Yes.
This court does not
That it be
expunge things.
expunged from the record, and he said this court does not expunge things.
Mm.
Today he was expunging.
Mm-hmm.
He was expunging very crucial evidence.
Mm.
Not just any typical, crucial. On the basis that the accused had a look at it. So you're telling me, Mogane, that they had a look at all the witnesses, that they have the means to go to the SAPS and get the names and addresses and telephone. What you're talking of is something that honestly, you have more access than the accused to do such. Honestly speaking,
on the hindsight, there is also, to me, there is this attempt for me that I'm seeing of attacking Mngomezulu. Mngomezulu is a bad person there because he is really on his A game.
Yeah.
And anyone can see that. It doesn't take certain books to actually see that Mngomezulu, when it comes to this, is more learned, is more experienced, and is not fazed by the noise. He's able to move away from the white noise and deal with the issues that he needs to deal with.
Yeah.
So, by even pointing at Mngomezulu, you are casting that thing of saying, how did you get that information, by the way? So therefore, let's go and report you. Same way as it happened to D4. This is my own observation. Hence, the name Mngomezulu had to be thrown somewhere around it. In a sense, I would go as far as saying that the aim of that rant that didn't hit where it was supposed to hit, it was supposed to hit Mngomezulu. And therefore, Mngomezulu was going to be reported for doing something that the court has ordered that it must not be done. Only to find that Mngomezulu did not consult.
Yeah.
And he hasn't even gotten time to look at this document.
Yo guys, inkulu lente fihlayo la, like it's big. Whatever is happening here, it's big. Like I feel like an ant right now.
So when it comes to this trial within trial, Mngomezulu is the problem.
So Mogane said Advocate Mngomezulu brought a document that shows information on the KwaNongoma case from their system. On top, it is written Sergeant Mngomezulu, not sure if they are related. So this was a jab. This was to say that, okay, maybe you used your nepotism connection or something like that. That's what he was alluding to. You know, it sounded that way. It sounded that way. And he said he's not sure if they are related. And he said, I'm
Do you
worried.
see now, where is that getting in?
It's getting to
the surname is Mngomezulu on the other side, and then Mngomezulu was relaxed. You know, it didn't need to. I know he sort of, that thing was like, what is this guy saying? I saw that face, but he sort of relaxed. He said, no, when it's time for me, my lord, I would like to exonerate myself to this whole circus.
So if they are that bothered by the extract, the only thing he pulled is an extract. So what happens when the defense pulls Ntanzi's bank statements themselves? What's going to happen? They're going to be charged. They're going to be arrested.
No, they won't. They won't be charged. But
what is going on?
But remember, for some odd reason, there was an order that was made yesterday, which I don't think there was an order that was made yesterday. I just tend to be corrected that this information should only be privy to the defense without
counsel.
Consulting with that. There was no such order. The order was that you bring this information here. Nothing much was said about what ought to happen after that. But then there is an order now.
No, I heard him say it yesterday. I heard him say it that the defense should not show it to the accused. It should only be for the defense counsel. I even remember saying to myself, Ushoguti, we as the public are not going to have the
Yeah, you're right. But that, how do you consult then with your client?
I don't know how that was going to work out. How are they going to consult with their clients with what they just seen in the
Because what I heard him saying today is direct what needs to happen. They need to go and tell their clients, yeah, there is a case resurrected. By the way, there is 1, 2, 3 case of Mngomezulu resurrected. That thing is here to serve. That's why I said this write a note or something like that. It has a lot of noise that was not yet recognized yesterday. And today, it came to light that there's a lot. But seemingly, Mngomezulu, without just us observing, this is me observing where I sit, Mngomezulu is the problem. If you had a certain narrative that you needed to push, I'm just saying, if you had, in this case, and Mngomezulu comes, Mngomezulu is the person who breaks that whole thing, and he breaks it with law, and he's able to code law on the stand like that, and that's a problem.
It's a serious problem.
That is the problem. So the distraction with other defense would work because they need to go and consult, and then they get distracted. Mngomezulu is not distracted because everything he needs is in his mind. You know, whatever law that he needs, right? He hits right here. You correct him along the way, but he has distracted you also on your process, and is moving also in the direction. Can I continue, my lord? And I see that Msholo has adopted that style.
Yes, and I'm very happy.
Of not being deterred from where he's going.
She even said at some point, before I got distracted, before the court distracted me, my lord. And the judge is like, I did not distract you. What do you mean?
Yeah, they need to keep on distracting the judge also on that process. They must raise these remarks that are making him agitated so that they can focus on what they need. Anyone who's not doing that is put on his corner, like Ngumalo.
Yes, Ngumalo was shut down quick. During the arguments in the morning, he was shut down pretty quick. You need to work on it, Ngumalo. You need to polish. You need to work on that because you are still going to meet worse judges than Rata.
I don't think there's worse.
Do you think there's You don't think so? I mean, in closed courts.
You see, the only time I think the courts need VAR.
Like to record. I'm still saying that no wonder why these cases are not made public. Right now, we could be pulling that Nongoma case. Do you realize that?
Obvious, because it was exhausted. It's done.
No wonder. It's the shenanigans that are happening. Like they are too much. They are exhausting, honestly speaking. I mean, what's the point? Why do you keep these cases? Now, today, to me in this court, it made sense today. Why? I saw it.
So the guy was literally indeed accusing Mngomezulu of using his relative to pull data.
And it shouldn't have to be that way in a democratic society or country. Once a case is closed, make the records of the court available for the public.
When you said he was reprimanded by authorities, what do you mean? What did you mean?
Reprimanded by authorities. Who said that? Mngomezulu?
He came back with that when he gave them the statements.
Oh, I don't know what he meant.
The authorities are everyone, the defense and...
Perhaps.
Or there's someone sitting behind. He's like a chief with a big voice. Go back. Give these people what they need.
Mngomezulu said he's not sure if they relate. Okay, Mngomezulu, this is Mogane's thingy of accusing Mngomezulu, and he said he was worried as to whether others would retrieve such information as he did. I would also like to ask, when I brought that document, was it for the lawyers or was it for the accused? And the judge said it was for the court. I'm shocked. In fact, I was supposed to peruse it first. I'm shocked that senior counsels like this can behave like this.
He was later corrected by Msholo that, by the way, you are not supposed to peruse first before we are privy to that information.
This gentleman is correct that people can be shot. Mngomezulu and Mnisi said that they never consulted their clients on the document, and Ngomalo says that he did. And Mshololo said that his client said that her client said that the accused were grouped together. Reading the indictment, which has to do with them, not the confidential what. They're not reading that. Basically, Mogane lied. Basically. I don't know why, but he lied.
That's why I'm saying that thing was
was
meant to do something.
1 page indictment.
And I think it failed dismally.
Because they didn't have the confidential what that he was talking about. It was not in their possession. Accused number 5 handed over an indictment to Advocate Mshololo, which has already been shown to them prior.
Which they are supposed to
know. So, Mogane lied in front of Pamkwabantu. In a court of where the public, the whole world is watching. He lied. So the judge said that they were reading for the past 5 years. That's why the judge is throwing shade here. He's saying that they should have read that indictment a long time ago. That's why he's saying they've been reading it for the past 5 years.
So what?
So the judge recalled all copies of Mogane's document. He said this document will not form part of these proceedings. This evidence has been contaminated. This court makes a ruling that this information must be expunged on the basis that other people's lives could be jeopardized. The judge asked Mogane about the docket, and Mogane said that the Foslorus 534 has long since been taken for a decision, and it's not yet back. The 534 case is that of illegal substances with regards to accused number 2. And then with regards to the Nongoma case, 163 of 10/2018, Mogane said that he had left it. Where he had left it, he did not find it. But Colonel Gininda said he took it and said he will look for it. But he said he will ask Colonel Gininda for that docket yesterday. Did he not say that?
He did.
So why didn't the judge ask? But you said yesterday you were going to ask Colonel Gininda for. Did you ask him? What did he say? Did you ask him? Because that's what you told this court yesterday, that it's what you were going to do. Did you do it? You never said that you had left it somewhere.
Don't trust this judge not to do anything like that.
Well, the judge handed back the document and said this document will form part of the proceedings, seemingly annoyed by Advocate Mshololo's request that the court must not keep the document for itself. And then he said, take it. I'm not that naive.
How can you lead up Mshololo? You must recommend it. I like this Mshololo.
I like it.
When he's moving in that direction and not deterred, I like it.
She's no longer emotionally.
It's no longer that smiling Mshololo with Mr. African. You remember, Miss? Yeah.
No. I'm sure if Besta is watching, Besta is proud.
This is a demonstration. It's a practice.
Because this is a movie about Besta, Mshololo. I don't want to lie to you. It's going down there.
That's why you need more reading than this one.
So I'm sure Besta is feeling like my money is going to the right place. Because wow, he said, take it. I'm not that naive. That's the judge. To keep it in my office.
You were doing that, Mos.
But he was going to go.
You were standing
with
up with that Nazareth of that thing, that that I don't understand why they wear it. You were standing up with that Nazareth of yours in Ngubeza. You were going straight
to the office, Gayo. So on the post-lunch sitting, they were still on the copies of that confidential document, and the judge said that he had originally ruled that the order must be expunged, but after consulting authorities in terms of our law, there is what we call a posterior ruling statement, a formal statement endorsed on a trial record. Then the judge said that that is what I'm doing. I'm placing it on the trial record, giving an account of the proceedings of the trial, a record of what had been done, a record of what had occurred after the issues had been joined. So in summary, the High Court in Pretoria unexpunged the document detailing the cases that witness Sergeant Vusmusi Mogane was ordered to bring to court. The document can now be part of court proceedings. And Mogane said that he saw the accused reading it and moving towards the other accused who seemed to have a look at it. And the judge said, can you give each and every accused that order so that they can read what the order says? And Mshololo said, for clarity, I can read it, but not consult. And the judge said, you can read it and share it with your clients. That's why I insisted that the document should be given to your clients. So it mustn't be said that this information was withheld. And Mshololo said, on the 19th, continuing with the cross-examination of Mogane, because now I'm sure she was happy that that document is back, because it had been taken away.
The judge insulted the defense. Yes, you are right. He didn't apologize there.
No, he didn't apologize.
No, he never apologized.
He falsely accused them of things. He accused them of giving their
There's no VAR to say that. No, actually, these people did not read this thing. And people are laughing at me. That VAR would have said, 5 minutes.
Let's look at the record.
4:10. Instead
of listening to the record, let's look at it. Let's look at the record and what the record says.
4:10.
Hi, Shem. Mshololo then started with the cross-examination, said on the 19th, early in the morning, you received a call that an accused person should be taken to Colonel Rapad. Did you take him? And Mogane said, yes, we took him to Moroka police station. Am I correct to say that the suspect did not sleep? Look at the time he was booked out. And Mogane said, I disagree, because he was sleeping in the car.
Oh, yeah.
So the very same police officer who was triggered at the thought of witnesses being shot and being pulled their addresses from the system, and just at the sight of a confidential document from the accused, this very same police officer is the one who was driving around while attending other cases with accused number 2 and having him sleep in the car.
Take your wife and make them sleep on your car. Let's see how that is going to end.
And he's speaking like it was such a privilege and an honor for accused number 2 to sleep in the car.
It's a fortune.
It's such a privilege and an honor.
Yes, my lord. We submit that it was a privilege to even my lord sleep in a white Fortuner. And it's not like he was traveling with a van. My lord,
this man is not taking us serious. Yesterday, Izolo Loco, he was saying that he was going to be bored in the cell. Well, at least there's a bed in the cell.
If there's no bed, there's a blanket.
At least. Not a van. Not sleep. And he's tall. But Humbamudim. Not this man. Can he please take us serious? Can he take us serious? Because this is not funny anymore to me. Then Mshololo asked, but he was not put in the cells to sleep. Baloyi said, what is the basis of that to say he was not booked into the cells? How Baloyi? You cannot be serious either. You don't see anything wrong with a police officer driving around with a person you considered a high risk, so much so that you had EMPD with firearms guarding this person.
We're talking about Baloyi. Who's that?
You cannot be serious prosecutor. There is no way. So Mogane then said there was a time we put him back in the cells and he slept, even though I'm not sure for how long. Kana, how long did he sleep before they woke him up again in the early hours of the morning?
He actually, what they said is he never slept. They filled the documents and did everything and then they moved. If you remember, there was such thing as that. Now he slept.
Now he slept in the car while they were attending other cases. How possible is that? Hello,
These people
somebody.
were not sleeping.
Sure. Mshalola then said, finished her cross-examination and said, "Thank you, my lord. I have no further questions." Well, the state re-examined. Mogane said they took Bongani Ntanzi to a dentist. When we were investigating, this is Mogane now testifying, there was a picture that depicted a person who had a gold tooth, and we wanted to check if he had a gold tooth. And it's also the people in the house that said that certain intruder had a gold tooth. Now, to our surprise, when they were testifying de novo, there's no longer a gold tooth that was being mentioned. Right?
But the means to check a gold tooth were already done.
They're already done. So in a shocking turn of events, right at the proceedings in the Senzo Meyiwa murder trial, a medical report handed up by the defense has noted no signs of abnormality with accused number 2. So this is what Advocate Baloyi had done. He now introduces this medical report that the defense had given only a page of. He read the entire thing and introduced it now as a new exhibit that Mogane was going through with him now, right? And when they were handing it to him, it was not for what he's doing, but he's doing it anyway. And he said, well, it said that there were no abnormalities with accused number 2, Bongani Ntanzi. Well, we are not really surprised, okay? His bank statement also had no transactions after he got paid on that weekend. And now this medical report that Advocate Tifo, remember guys, and Titi Tobani said was there to prove that he had been tortured, now says otherwise, like the bank statement, right? It says otherwise to what accused number 2 said, that he was at a wedding, he was getting married. Yeah, it's a lot going on with the paperwork. Well, this 22nd June 2020 medical report was obtained at the time that the defense says Ntanzi was being tortured, tubed, assaulted, and choked. So during re-examination, State Prosecutor Advocate Judge Baloyi referred the witness, Mogane, who, according to the defense, had witnessed the accused's torture to a medical report of the 22nd of June 2020. Now, the oral report indicated orally that there was nothing amiss with Ntanzi. General appraisal, no lips, no buccal mucosa, normal, pharynx, tonsils, normal, flow of mouth, normal, stated Mogane, reading the report into the record. So the problem here is with, before they drove him, before the boardroom interview, right? When did the alleged torturing happen according to accused number 2's version? Did it not happen after they drove with him to Rustenburg? It's not even Rustenburg, Western area. It happened after, right? So how is this medical report supposed to, the one for the teeth, supposed to say otherwise? Because there was a lot going on. Everything was normal. Like, of course, everything was normal because according to accused number 2's version, it was before the torturing happened. Baloyi is trying to confuse us, guys. He's trying to confuse us. The pharynx and tonsils were
You should
normal.
look at him. When you look at him in that thing, when you look at him, when the camera is, but the cameraman, can they focus on him?
Flow of mouth, normal, stated Mogane, reading the report into the record. So he used Mogane to read that report into the record to prove that there was no torturing. But it doesn't support the accused version. It doesn't align.
It's not after.
No. And then Mngomezulu, who handed up the document, challenged the report referred to by the state and he had a problem with it. He said that he did not hand it over for what the state is now doing, right? And oh my God, he says when he handed up the medical report, it was not on the contents, but on the date. So he was using the date for that medical dentist, because he did mention it with the accused two's version. Remember, there was a time he mentioned that they took him to the dentist, which the state did not provide and did not mention.
Yeah.
And then Baloi just took it and said, this can work in my favor. But look at how he's manipulating it. Because according to accused number two's version, the torturing happened at that Alberton dumping area, right? He was being taken from pillar to post after they went to Western area and Carltonville and got these medical reports. And in 2014, apparently had a heart problem from working underground, right? 2014. So here's this man who had a heart problem. He decides, let me go and rob at that Spaza house and take one cell phone. Hi guys, kuningi. And then there was Mjiako also mentioned. Okay, Mjiako, they tried to clean him up, and the judge was also assisting. We had the privilege of hearing his practice number because they are watching the socials and they're saying that. I was surprised that the judge mentioned that, guys. I don't know whether you caught it. He said that there are people who are saying that he's not even appearing on the LPC website. He doesn't have a registration number. Could this be a ghost? Is this Mjiako even a real person? He mentioned that and he said, give the record number, give the office. Where is the office located? No, give it. For
Where we want it. And when did you start practicing?
2017. And the funny thing is that when he represented accused number 2, he was going under Mjiako attorneys. And then they are saying now he's left the Mjiako attorneys firm. He has left. He's at the Cape Town board now.
Oh.
And then another interesting thing is that he did not receive financial instructions from accused number 2. He wasn't getting paid, basically, by accused number 2. Where did he come from?
That's what they said?
Yes.
So he was not getting paid?
He wasn't getting paid. He wasn't receiving any financial instructions.
He was not also, what do we call it? These ones who always say, admit to negotiate.
Legal aid, no.
Legal aid.
No, he was not from legal aid. He was from his own legal firm, Mate Mjiako Attorneys. And now all of a sudden he's left that legal firm. He's at the Cape Town bar right now, according to the testimony. And they're making Mogane read those details. So it means Mjiako is not coming to testify. He will never come because he was his lawyer. And apparently there's a law that a lawyer can't testify against their own client. So they're making Mogane clean him up.
Well, it is what it is.
Okay, the lines are now open.
Yeah, the lines are open. Let's hear what people have to say. We have had our fair share.
It's a mess. When I heard them Mjiako details, I was like, oh my God, this is even worse than...
Closing loopholes.
You should have just kept it to yourself. You know, the fact that he wasn't getting paid. Who was paying him? Who was paying him? And why was he showing up and not showing up and showing up? And what was going on with this Mjiako guy? Like, he sounds very dodgy.
He is. Sounding very dodgy, allegedly. But let's see what you have to say. And if you've got nothing to say, we welcome that.
Sure. He started practicing in 2017, according to what was read today.
So a dentist report.
And he's from Veiws, apparently.
So a dentist report was giving medical examination.
Yes, the mouth, the tonsils, I was worried. I'm like, this is the medical report that Tefo was talking about. Is this the one? Is this the... No, it's actually the dental A dentist report when they were checking for the gold tooth.
And they were looking for tonsils on top of it.
Tonsils. Just to show that there was no punching. And you know what the funny thing is, Mr. Anonymous? I'm only catching it now. That's why I love these live streams. Like, when I overlook, because during the day I was so pissed. I'm like, where did he get this medical report? Where did he get this medical report? And now I'm like, oh wait, it's a dental report. That's why I love it coming over here. Siyaphila ninjani?
Siyaphila. Hey, no, today it was hectic today, man.
Aye.
Hectic.
The problem enkulu i-judge I think he's suffering from ageism. Yebo. Lento uyithatha ngokudala then ayisebenzi yabona. So akafuni ukuchallenge most of the time uma ubheka umshololo mangabe emchallenger since today athe izolo lelona lena uyayimisa ababuye nobufakazi umshololo ubuyile wa refera pekwe judgment of which state sihlulekile naso ukuveza okwaso. Then on top of that uchallenge umshololo naye ufuna ukufaka naye yena always uhleza defend yabo akafuni ukuvuma ukuthi wrong yena ufuna ukuchallenge every time.
Yes.
So lento leyo inzima. I think yabona umuntu okhulile umuntu omdala akafuni ukuphikiswa noma wrong always yena right. So ayisebenzi kanjalo because ngendlela ngibanga ngakhona ukube awekho ama-camera ngabe kwenzakalani behind the scene. Ngabe asiwabona onke lama loopholes lawa ngabe nje imess ngendlela ngibanga ngakhona ngabe kuningi nje okonakalayo. So manje iyo lento emshaya ukuthi uyabona kune information ayitholayo njengoba nje akhuluma ngeindaba zokuthi kunabantu abathi umji yakho akaveli in kuma system. Shothi uyabona ukuthi abantu bamblame even if you can check mhlambe ko SABC uma ngabe benza ama interview lama attend lawa email bachaza ngayo ukuthi ubehave kanjani. Uyazibona zonke lezi zinto yizo izinto ezimbambayo manje ukuthi angakhona ukuphusha le agenda afuna ukuyiphusha.
Yeah.
Ngendlela ngibuka ngakhona. But I'm happy ngomshololo. Umshololo uyalwa.
Yeah.
Une fighting spirit umshololo. So if angaqhubeka ngalendlela lena I think sebamfundile kwayena lo judge sebambonile ukuthi operate kanjani. Yabo. Because uma ubheka umshololo ngendlela am-addressa ngakhona you can see ukuthi no umfundile uthi hayi lo lona kahle uyidefender estate. Yeah, i-backline. So I'm happy ngomshololo noMngomezulu. And ngendlela ngibonga ngakhona noNxumalo naye ufuna ukuthi kunyusa kancane amasokisi.
Yeah.
Ngathi uNxumalo man ikhale one way ngoba manje ngibona ngathi uNxumalo uthule kakhulu ngibone today he was paralyzed. Uthule ngiyabona u30 second wonke ngathi kwenzakalani uNxumalo. So of which ngicabanga ukuthi no enye into engayibeka Mr Anonymous ukuthi i-status nayo i-case kahle uma ubheka nje lobufakazi obulethiwe before i-court status na case ayikho i-case nje they must release these people because even kwayena lo mhalo uyabona nje every day uza ne-new evidence every day besingazi ukuthi uNtanzi walala emotweni kuvela manje into angayifakanga leyo. So every time kuba khona a new evidence that will be introduced by Muhale. So I don't think kuneqiniso lapho. Uyabona nje it's a hogwash this thing.
Yeah, it is.
It's something that is cooked.
Yes.
Yeah, so yikho nje ngakusho Anonymous ngiyabonga mano Emily.
Sibonga kakhulu mfethu. Right. All that is said here, Emily,
is alleged.
Alleged, and
the views and opinions expressed on this platform are not that of Mzansi Reality, are that of the individuals separately. Yes. Disclaimer.
Okay, so that whole drama of Mogane pulled today was to take a jab at Mngomezulu. It was an attack. At time now, today, the judge says again, in case this case goes somewhere else, Ushoguti Lobaba is already sitting with the judgment. Yes, Mogane lied, and this was another proof of that. He's not credible witness. If he can create a story like that, what else can he? What else is he capable of? Medical report was not done by dentists. Dentists are not equipped to diagnose medical conditions, assess injuries. How do dentists diagnose soft tissues injuries and broken ribs? Because their scope is on the oral cavity, but to tonsils is not caused by abused infection. Yes, Dankilab. I don't know if I can play this one.
Good morning, Mr. Anonymous. Mr. Anonymous, this guy, he wrote the statement yesterday. It's just a statement of what he has done on the day that he booked out accused number 2, which he went to do investigation on certain cases that he mentioned on that statement, or he quoted on the statement. But he's scared of the witnesses on the same matter, which he was with the same accused. How can you go with the accused and do investigation, and then you pretend to protect the witnesses that you conduct investigation in presence of the suspect or in presence of the accused? No, that is uncalled for. This guy is trying some tactics here. And I won't be surprised if an inquiry can be opened for those printouts that was in possession of Advocate Mngomezulu, because they are trying by all means to disarm Mr. Mngomezulu, because he's the one that is currently trying by all means to, to destroy or to dismiss their, what is this, confession. Thank you.
Thank you. Guys, I see that some of you are calling this other side. I'm trying to see what could be the problem, because I see that many people are calling, but I'm getting only messages.
What does that say on the credibility of this witness? The fact that they can lie in front of a judge, and the judge ran with the lie, by the way. Is he going to look at the effect of this witness lying with a straight face like that?
Hey, I don't know. Zanzi, hello?
Hi, Mr. Anonymous.
Hi, sir. How are you?
I'm good. Are we live? Sorry.
Yes. We've got.
Okay.
Yeah.
I think for today, firstly, let me greet both of you for a stellar job that you guys are doing every night. And I know that for a female having to be up and having kids, it's probably not the ideal thing to be at this time or every night for us. But we appreciate that.
Thank you.
I think for me, there were several things that stood out. And I think at some point you guys didn't mention Malo. If you checked when he spoke, he had a police document that he had. It's just that because of the judge was too quick to shut him down, it wasn't something that was probably mentioned or focused on, because when he referred a question to the witness, he was reading from a police document and not any court judgments of the procedure, I think it was. Okay, which means that he did his research and trying to reflect it back to the court in terms of how they should operate and do things, because the judge was trying to find court cases that were in 1931 or something like that, and 1996. And I think as a researcher myself, if you're a person who has gone through university, normally, I can speak under correction. When you write papers or do something, you would always reference to your latest paper that was written. So in this circumstance would be, if there's a judgment, you would look to a judgment of, let's say, 2022.
Yes.
Or 2021,
Yes.
or maybe 2000, instead of going, because there are many cases that have been done, unless it has not been done, and then you have to refer to the old cases.
The one that
And,
did was more recent.
Yes. Mshololo had a way more recent one, and the judge was bringing two, which Mnisi actually cut out because he found it they were irrelevant to this particular case, where Mshololo is bringing one that pertains this issue.
Yes.
The judge brings two. I think it's we're going back to that thing of the judge throwing names and using his power, because if those two judgments were concord constitutional judgments that he brought, so it's almost a status thing. These two are better because they were at the constitutional court, but both of them had no merit to this particular case.
Yes.
So in anyhow, you can bring two things, but if they don't assist on the matter that we are discussing, what's the relevance? Because you're now trying to just bring things that, it was from the constitutional court, so it means that the constitutional court said we can trump anyone's rights, constitutional rights,
That's what
based on what those courts said on something that is irrelevant. And I think that was when Nisi was standing on, that these two things don't align. And also that Nisi stood, which I appreciated, was he says, Michelle, you told us to go study these things and bring some education or some teaching. Michelle Lolo has a paper or research. The state has done nothing, no homework. It's waiting. You, the one who's actually has two judgment, and you reading it.
Yes.
I'm paraphrasing now, which for me doesn't make sense in the term of, so they go behind, and then the cake was when he says authorities, and then you're like, but aren't you the authority in this courtroom? So other people, other judges are making findings or telling you, then you're not impartial to this case, because you the one, there can be a judge president or whatever, you're the one who has to make a ruling on this case, so that if it's taken under review, it's taken on your behest, that you are the one who made the wrong judgment, and not a judge president or someone behind the scene who's an authority. It fits with the narrative of Concord, Afrikaans or apartheid laws that he uses. So it's all these things that are so heavy that people like Mumalo feel, oh shucks, this guy is using heavy stuff. He must be right. And it's all that smoke and mirror type of narrative that he does bring. I'm trying to think something that also probably crossed my mind before I let go. But I think one thing that we need to it's tiring, this case. I'm feeling it myself, because today we had to deal with Rata, whatever his surname is. I call him a Muhu, so because it's easier to say Muhu. But what hurts me is that the way he speaks because these are parents. As much as he's a grandfather or whatever, these are parents, and I feel there's no job title that any one of us can have that gives us any right to speak down on anyone.
Yes.
And then he knows that because he's the judge, he can overrule and tell them that they are in contempt of court if they challenge him. Because if it was me, I'm sorry, I'm Harakat, so I would not take that. Because if you're wrong, you're wrong.
Yes.
And you need to apologize. I do appreciate Mr. Mngomezulu for not standing up. I would have liked, though, that the other 3 or 4 stood up and objected to what the witness did, because not the judge even didn't come to defense. Because if you check when the judge went off on Mngomezulu and everyone, it was after Mshololo put him in his place. So he wanted to get them back. And this piece of scathing, it's a scathing remark towards Mngomezulu by the witness, actually gave him a loophole to say, I'm now gonna tell you where to get off. It is wrong to do this. You can't do this. And that's where Mnisi also stood up, and he was offended in the wording that he was using, because Mnisi realized, I'm not a child.
Yes.
I'm a profession in this work that I do.
Yes.
And Mnisi didn't know about this, because the only person who knew about it was Ngumalo, who had spoken to his client, because he was the only one who spoke to his client.
Yes.
And did what he did.
Yes.
But even when Ngumalo said that, Ngumalo did not say that he showed that particular document. And nobody came back and apologized, because we still don't have the clarity that it was that document that Ngumalo showed. Because it was an allegation that the witness made. Because he's at the dock. He's seeing a paper, how far?
Yes.
Of people sitting down, and he says he could see that it's written confidential. For me, it's the distance. No one else sees this. Everyone is confused. Even Baloy, I'm sorry, he was confused.
You think Baloy was confused?
But no. I find that he was confused. Maybe acted, but I do realize that it was a planned thing to bring it after the break, because now the witness has balls to say, Your Honor, before I'm cross-examined, there's something that I want to get off my chest.
Yes.
Like really, like now you have the balls to say, I can speak because I saw something. Someone saw something. Baloy probably gave that purposefully, and he saw and told that guy to bring it up and not him. That could be a situation that happened, because he's the only one who knew that he had made copies. And this gentleman is saying, no, I gave the original. Mr. Baloy, how many copies did you make? He's not clear. The judge is asking, how many copies did you make? Because Mshololo did not have a copy of this document.
Yes.
She didn't.
And that is the weirdest thing, is that, so it was intentionally done so that the judge could reprimand, and that this information could be used somehow against the defense, in saying that people are going to die, like Zungu, when Zungu's life was in danger.
Yes.
Now another person, these guys are so dangerous that even if they are in custody, they have so much power. If you give them any information, they will make people disappear. Before I go off, there was a gentleman who called last night.
Yeah.
Who was a police officer.
Yes.
I've been thinking about him, because I heard about a case this late afternoon today, about 2 police officers, I think it was,
Yes.
who were going to give testimony and who were gunned down at the court. And it made me think about this gentleman who made those allegations last night. And I'm with you to say he made allegations, because we don't have proof. But those who know, I'm thinking about his life. If police officers can take one another out, when some of them who have the courage and who are good police officers, who are standing up against these nonsense, can be taken out in front of court. And I think that is a very big concern within South Africa right now, that if you're going to be standing up, this is the repercussion that you're going to have.
Yes.
Anonymous, Marcelo, Emily, have a wonderful evening, and thank you guys for listening.
Thank you.
Thank you for calling. Thank you so much.
Right. Yeah, I hear, guys. I get you. You are saying that the number is not working. I mean, the number indeed is not working. I've checked. Zanzi, hello.
Which one?
The cell phone number. Please reduce the volume.
Do we have a network?
Hello, can you hear me?
Yes, I can hear you.
Yes. Can I go?
Yeah, you can shoot.
Oh, okay. How are you, Emily? How are you, Anonymous?
I'm good, and you?
I'm good, thanks. Yeah, I think, just to maybe add, I think I also have a theory, just to maybe add on the theory that you alluded to earlier on. To say with that situation, with because there was that extract, right? So, which I still believe that it's just typings of the case, not really something that was extracted from a system or something. It's just him typing that here are the case numbers, and that's it.
Yeah.
So with that, the reason why they didn't want to, so I think they wanted to conceal that so that it's not part of cross-examination. So that was a ploy. That whole thing was just a ploy so that the judge can rule and say, no, you can't use this for cross-examination anymore because now they're going to cross-examine on, because Mshololo couldn't even continue on that line to say which cases did you attend, show us the cases, and so they couldn't continue in that line of process. So they succeeded in that regard, but I think that was part of the plan.
Yeah.
But now when he made the ruling, I think it was an impulsive ruling. So at the end, when Mshololo stood up after when they were about to adjourn, I think she that's when he realized that, oh, I made a blunder here, because she said, my lord, you can't take an exhibit from a witness and keep it to yourself without it having been. So that's not how the court works. You need to. The witness comes and submits evidence through the state or through the defense, and then then the defense or the state submits to the court.
Yes.
And then, but what he was trying to do was unprocedural. So I think that's where he realized. So when he went for lunch, he consulted and they told him that, hey, my man, this is a publicized case. I think he also made that comment when he came back. He was like, I think he was agitated, like, this is a publicized case. I think he said something like that. So it means then they know that this case is being watched by a lot of people. And
It's too late for
as
that.
much as it's too late, as much as he has an agenda, it's like he even mentioned the SCA to say these things are going to go on appeal. So even if he's on that side of the state, the facts are the facts, the law is the law. You can't change those things. So, and it's argued in public. So, like, I don't think there's any way around it.
Yeah. There are many blunders he has already made.
Yeah, and whatever they do, I don't think they because now the public is watching. Like we see, even with the judgment that he wanted to do before with that the evidence about when he made the ruling to say Mshololo could continue with the cross-examination with that whole interview thing in the boardroom.
Yes.
He had already ruled otherwise. He was trying to rule otherwise, but he realized, like, all these guys are coming with the law, and there's nothing I can do.
Yeah.
And then, so I think at this point, there's not much. Yeah. As long as the guys bring the law, and I think there's nothing to worry about.
Yes. No, we hear you. Thank you.
Yeah, no, that's all, man. Thanks.
Thank you. I have to make it, I have to put it here that today, I guess it's a WhatsApp day. Then tomorrow, when we fix all the problems of this other number that is now refusing to go through or blocked, I don't know who blocked it. And then we will be the day for that.
Now, someone was asking, was this Mogane's plan to have this made-up cases, alleged made-up cases that he was working on for 17 hours, accompanied by Ntanzi, since he didn't want him to get bored in his cell, expunged from the evidence?
Then it did
his
happen.
Plan didn't work.
It did happen because I was never questioned about them.
No.
After all that circus that happened, it was difficult to even question about them.
And they still need
in a sense, they are not given much more airtime on these things, because what they are literally saying is classified information. You cannot question.
Yeah, it's classified. They cannot make it public or expose. So they need to prepare. I wonder if he's coming back tomorrow. I'm just wondering, is he coming back tomorrow
Did Mr. Vaselina finish cross-examining?
I don't think so, but he might say that he did in the morning. But I don't think so. It didn't sound like he was done. But he might say, I'm done. Just for the sake of.
To make sure that he doesn't come back. Right. I think this is the time where, Emily, I start reading people who are here. And then you'll get some there also, I think, if you are able. Are you able?
Yes.
Because I think it's time for us to adjourn this court of public opinion. Mandisa Kwebulana, and then Sia Skulu, Mamburu Abashwe. Thank you, guys. This is now the time where I say thank you for being with us. Net, thank you. Nyasha, thank you. Tando Masia, thank you. You wrote something here. These 199 witnesses were not supposed to witness against the 5 accused, but against the 7. Those were at Makumalo's house on the 26th. The October 2014, where Senzo Meyiwa was unfortunately gunned down. And just to continue with the Lindy, Lamini, Zanele, Sankobe, thank you, guys. Bruno, thank you. Tabisom Daung, thank you. Mimi, Loliwe, thank you. Ansi K. Moyo, our moderator, thank you. Joe Manara, thank you. Mpo D, thank you. I see that something is happening, but it's just missed calls, guys. You can call on WhatsApp if you guys want to call. Nomusa.
Okay, Mpo Musi is saying that he's coming back. Rata did ask him. Okay, I missed it, guys, but he did ask apparently, and he is coming back tomorrow. No, he must come back, especially now that they've introduced new evidence. He needs to be cross-examined.
Oh, they're going to cross-examine. It's done.
Sure.
Hello, we'll be finishing. Vusimuzi Mkosi, thank you. Michael Lee, thank you. Let me take this caller. Zanzi, hello? Zanzi, hello?
Hello.
Hi, how are you? Can hear myself though at the back.
Hello.
Hello, how are you?
I'm good, thanks. And you, Mr. Anonymous?
Not bad at all, not bad at all.
It's Lufate here.
Lufate. Hi, how are you?
I'm good, thanks.
Yes. Lufate.
You know, even though the defense didn't cross-examine on those cases, the fact remains that they took Ntanzi with them, Galavant with him for 17 hours, so Ntanzi was sleep deprived. So it doesn't stick, even if they can say even if they are not using the cases, the fact that they have put it on record that for 17 hours. I mean, who sleeps for 2 hours? Sleeping in the car is not sleep. It's not rest.
No.
The reason why we need to sleep is because we need to rest.
Yes.
So that's my submission, my lord.
Thank you. Thank you. Thank
As
you.
the court pleases.
Thank you very much. Right. Thank you, Lufate. That's a shout out also because we normally miss you. Don't comment a lot.
Yeah.
You comment at the beginning and then you do stop. But Lufate has been here as our moderator.
It's very
thank you.
recognized, the Lufato member of the channel.
Right. Nostelo. Thank you. Ngema. Thank you.
Amalia. Shihama.
Yes.
Watching from Namibia.
Namibia, all the way from Namibia.
Yes.
Modley. Thank you. Lindy, thank you. And Sizwe. Mkaka. Thank you. Buzuwake. Muziwake. Sorry, Muziwake Hadeb. Thank you. Siabulela Mzizi, thank you. Elizabeth Jenje, thank you. And then we have Tuli Tools, thank you. Constantly there. Miss K, thank you. Abanga, I have. Caroline, thank you. Nomusa, thank you. Joe Monare, thank you. Spa Masugu, thank you. Let's see, this is not good. Emily,
yes.
I think I'm done on my side. But there's someone here. Mzansi, hello.
Let me just reduce the volume.
Yes.
Not a problem.
How are you, Mr. Anonymous?
Hi, how are you?
Yeah. Yeah. And Emily, how are
Hi.
you as well?
I'm good.
Yeah. I'm just confused about these cases that they are trying to hide. Aren't these cases over? Are they still running?
Apparently,
the Ngoma
they've
and
resuscitated them.
Well, the
they've
police unit has resuscitated them.
Oh, okay.
They pumped life to it.
They make it hot. He said we take cold cases, we make them hot again.
After there's been judgment on the case.
After there's been judgment on the case.
Doesn't matter these
Only
days.
in South Africa.
Doesn't matter these days.
Yo, I'm fuzzy because I was gonna say if Koguti the cases are like there's judgment given on them, unless they are sealed for whatever reason, there's no need for them to be hiding them. So I guess they're resuscitating them so that they can hide whatever info
So
that they want to be hiding.
Like a pending case.
They are like Jesus of the cold
They've
cases.
been resurrected.
I ukuthi anamanga shame namaphoyisa ukuthi the other ones they go to Nongoma to get notes, and then the notes are shredded by Gininda, and then the statement is left with Gininda, and then today they come back, it's not where it was. Yo, hi, kuningi.
Hi, kuningi, case.
Kuningi.
Nomnazaretha, we judge.
Don't quote me to that.
You wanna feel. No, good night, guys. It's confusing. It's actually not confusing. They're just cooking things and it's not working. But anyway,
it is what it is.
Yes. Yeah.
Thank you.
Kuzophela, hopefully. Thank you so much.
Right. Welcome, Kambule. Why is the judge dragging the South African justice system by making the case have two prosecutors, himself and Maloyi also? He is an boasting on that. Boasting on living on those times. Hi, Emily and Mr. Anon, watching from UK. Thank you for your good work. We thank you. Thank you, Mr. Nmas and Emily. Sfiso Moyo, thank you. And Zanele, Beck, Mini, thank you. And then Zandile, thank you, Zandile. And Mandisa, thank you. Bye-bye. Chuku Anna, thank you. Bye, everyone. Bye, Bruno. Bye, Spa.
And Siabulela Mzize says Emily, we are Pilapo where they make cold cases hot again. It's not me, it's Mogane. He said that yesterday. He said they make them hot again.
It's a good advert for Nando's.
Yes. They cold cases, make them hot again.
It's a good advert for Nando's.
Yeah, he did say it. It's not me.
You just ate cold meat? Cold case? No.
No.
We bring it back.
Hot again.
We will make it hot again.
We take a cold case and make it hot again. Yeah, it sounds like a nice Nando's advert. It would make.
Watching from Australia, Kawe. Thank you, Kawe. Tando, Masia, bye guys, bye Ziakala, and let me see, SD. Thank you, our member. Larry, thank you. Just looking for people that haven't called their names here. And Chris Ndovu, thank you. Emily.
Yeah.
And Nomcebo, Camille, Langamanda, thank you. Night, Debuo, Joe Monare.
Joe Monare, I did see Joe Monare.
Yes.
Chris Ndlovu, Lerima Hobie.
Yeah.
Nomusa Ndiweni, Hamasuku.
Yeah, you can just shoot a minute and then we are gone.
Look, man, I have a question here, man.
All right.
Is this guy going to be called back? Because I don't think he has done the cross-examination. Because there are those dockets that are still outstanding. When those dockets are found, is he going to come back? Because remember, we are still in a trial within a trial here.
I would like not to see him again. I would like this trial within a trial to just exhaust and remove this whole situation and put us in our ease, and we continue with life as usual. But if your submission is, in fact, you are supposed to come back even here, because those dockets are not submitted, unless then they are going to reduce it into arguments. And
those dockets are the most top point on this trial within a trial.
Obvious, but the judge is gonna. Is gonna. You know how the judge is.
Yeah,
is it important?
Not taking them serious. It's immaterial.
Is it important? I mean, where are you going with this? Where are you going with this? Where are you going with this? You know how it is.
But it is important because the guy was charged, was arrested on that normal case.
Yeah, obvious. The Ngoma case, we all know where it sits. Ngoma case, not in Johannesburg. It's in Kwanongoma, and it's a case that was dealt with. But well, they make it hot again.
And I won't be shocked that the case, after it was dealt with and the judgment was given, went back to the station and it was filed in archive. Really. Maybe the reason why Gininda is not in the office to find a docket and give it to him, but the same docket that he left it in the office today was on Gininda. It's because the docket is still in the archives at Kwanongoma. And secondly, the docket of possession of what you call dealing drugs is still booked for what you call for decision.
Yes.
Since those years, fuck this guy. Sorry about the language, but
People said this is a fucked up situation.
You know what I mean?
Lie.
It's frustrating. It's frustrating, really.
Yes.
Okay, thanks.
Thank you.
Good morning.
Good morning.
Thank you, man.
Yes.
No, he didn't lie. This is a effed up situation.
But to say Mhlanga, thank you guys. Bye. Emily, anything?
Nothing, guys. This is an effed up situation.
It is. It is.
He didn't lie.
It is.
The longer it proceeds, like the worse I see that, oh my God, this is actually a nightmare.
Yeah, but if you don't wanna, yeah, that's fine, guys. It's a bye from me. I'm not taking any calls anymore.
See you tomorrow, guys.